list, item number 1 and batch of matters.
Any matter to be accepted?
May I mention, my lord?
Yes, sir.
Read petition number 5478, my lord.
Yes. What do you want?
My lord, this matter was pending since March, and their direction was given to the opposite party to file counter affidavit, and this thing is not followed, my lord. And another, my grievances
Please
are
wait.
still pending.
Make a mention. Please
My
make
lord,
Monday. Please make a mention on Monday or
my lord,
Tuesday.
may I request, my lord, this urgency is that, my lord, that my representation is pending there.
Mr.
And in
Counsel,
every likelihood that
Mr.
the
Counsel,
result will be out, my lord.
please called out. List has been called. Please don't interfere. Mr. Counsel, please don't interfere.
Lordship, in this batch of matters, WPC 1596 of 2023.
Please.
Lordships, in this item number 1 of the special list.
Yes.
Yes, my lord. Item number 1 of the special list, my lord, WPC 1596 of 2023. There we have challenged the constitutional validity of a CBIC circular in this matter.
All right.
My lords,
Let
my lords,
me-
only the, my
All
lords.
right. So,
Grateful, my lords.
The matters of the segment.
let's see.
Lordship, in case number 30395 by 2023, at the first appellate stage, Lordship, the tax demand was 27,50,000, and 10% of it has already been deposited. That is
Do you
2,75,000.
want that common order?
No, Lordship, there is a difference, my lord. There is a difference.
All right. So clear it separately.
309.
309. Any other matter? No. Okay. Let's see. I'm up here. Yes.
Supplementary list fresh admission, item number 1, W1873 of 2023.
My pleasure, Lordship. This is a matter relating to RTI Act, where the first appellate authority has been imposed with a penalty of 15,000 rupees, whereas section 20 of the said act says that the fine may be imposed on the PIO, means the public, means the information officer.
This is WA1873.
What is the single bench order, which is the annexure? Annexure 7. Yes. Come to the relevant part. Considering the submission made by the counsel for the party on perusal of the record, it appears that notice was sent to the petitioner in address of quarter one of this and this. A plea taken by the only counsel for petitioner that she being the first appellate authority, during the act upon the notice, as notice was sent to the public information officer. As such, the plea is not acceptable, as the petitioner should have responded to notice in her address and state the fact before the commission before adjudicating the complaint of section 20 of the act. It is further repeated notice that respondents are not addressed, that will be allowed. But here is a case, to me, there is two provisions in RTI. One is under section 80. That is a complaint case. It is a complaint case. It is not a second appellate case. It is not a case under section 19. So, the notice was issued to the public information officer, and the public information officer, under the impression that the information has already been submitted, didn't receive the notice. But I am the first appellate authority and I am not the public information officer. The notice was addressed to the public information officer, care of headmistress. I am the headmistress of the case of the school, and as per the provision, as per the notice of the government, in consultation with the maybe Annexure 3.
No, sir, whether it was not obligatory on your part to transfer the application which you had received to the public information officer?
It is the notice was issued to the public information officer. I am not the public information officer. I am the
It was
first
issued by
appellate authority.
whom? The notice was issued by whom?
Look, the complaint is that the notice did not received by anybody.
Notice was issued by whom?
Notice was issued by the complainant. That means the person who seeks information.
That
He has
not-
sent
that is- all right, notice under which provision?
notice was sent under section 18
Under section
as a complaint case.
80.
18. Sir, page 32, maybe seen.
Sir, notice was issued by the commission, not by the,
That is at the time of adjudication. At the time of adjudication, the first point, the first consideration is, you may see page 32, your lordship may please go to page 32. This is the complainant, the PIO, they are headmistress. In the due process, actually the person who is the public information officer, he informed that the headmaster is the public information officer. That is a wrong submission altogether. So, all along, even in the case of the commissioner also, the first notice was issued to the public information officer.
Who, sir, the question which is posed to you is that who issued the notice to the public information officer?
You know,
And where is that notice?
yes. Page number 28. Page number 28,
Yes,
complaint case number 96/22.
yeah,
This was by the second appellate authority, that is the state commissioner.
yeah.
It was sent to the Prabhat Kumar Saprati, was the complainant, and the notice was issued to public information officer, Government Girls High School, Unit 9, Bhubaneswar.
When the notice was issued?
Paragraph 8 and 9.
Just a minute.
Sorry, ma'am. Paragraph
When the notice was issued?
24/3/2026.
Okay, by that time you are
I am the first information officer. I am
you are the headmistress of this.
Yes.
The question which is posed to you, let us accept that at that point of time, you are not the PIO.
Yes.
You are the first appellate authority as per the notification of the government, right?
Yes, at answer.
Since you are the headmistress of a school and the notice reached you, was you not your obligatory, just listen and then answer. Was it is not your duty just to intimate the PIO, who is the trained graduate teacher. The senior most trained graduate teacher is supposed to be the PIO, right?
Yes.
So it is not, whether it was not on your part to just intimate that this intimation has come and you are to act. So have you not failed in your?
Yes, I have done that part of it.
Then
I have done, but there is something extra in this case. Actually, I instructed the
why question is that why did you remain silent after receiving this notice? Maybe that it has been addressed to this public information officer who is one of your teacher and the senior most teacher.
yes,
And as per the government notification, that trained graduate teacher should be the PIO and you as the headmistress is the first appellate authority. When such a notice has been received from an authority, was not on the part of your duty just to intimate the PIO to respond to this notice?
I have intimated him.
Where is that? Where is it later?
I have intimated, it is in
Where is that
the,
later?
actually the information has already been supplied to the complainant earlier. It has been discussed in the office.
It is very difficult, Mr. Counsel, for us to understand your grievance. Which order was under challenge before the writ court?
Annexure 7,
Annexure 7, page?
page 60.
Annexure 7 is the order passed by the learned single judge.
Yes, but Annexure 6 is the order.
Okay. That is at page 54.
Page 54.
Paragraph 6.
You are for the complainant.
No, my lord, I am not state information comes.
Okay. Who is for the complainant?
Whether
Whether the complainant has received all the documents which he has sought for.
See,
He or she, that
he has
complainant
received, through his advocate, which has been filed, he is a regular supplier of question papers.
His answer to our query, some documents have been sought for
Sure.
by the complainant, right? It was not supplied to him or her. I just want to know.
Paragraph 6.
Okay.
Paragraph 6.
That is the reason why she approached the authority. We want to know that whether those documents have been supplied to the complainant or not.
It was been earlier supplied. It was earlier supplied to him. He knows everything.
What is your instruction?
Subsequently, paragraph 6 of that order, page 55. Page 55.
Yes.
Complaint case order closing can see paragraph 8 in course of hearing on 16/2/2023, the headmistress submitted that the information sought for by the complainant was not supplied to him till date. That was
No, but what is there against this appellant, Minati Mishra?
Malady Lordship is asking question, what I'm answering. What in this particular matter? It is a-
No, what is there against her?
that he didn't supply the
She was
information.
not the PIO. PIO had
Correct.
declined to receive the application.
That is correct. In the period of the case, my lord, despite repeated notice, he has not received the notice and didn't appear. This is the case, my lord. That is where,
So is there any provision
Sir.
that if someone does not appear, he shall be saddled with fine by the information commissioner?
because he obstructed supply the
There is
information,
the question of obstruction.
because he didn't supply.
It
the-
was your specific case before the
That's correct.
commission that the PIO declined to receive your application. That was your grievance.
That's correct.
How can the appellate authority be punished?
That's what can I say, paragraph 8 and 55 case. Also, please,
55 we are there.
she has the PIO. She has the
Yes. So because he did not appear, therefore fined.
She has the PIO. That's what can I say,
What
paragraph.
happened to PIO?
She's the PIO.
No, he is not the PIO, he is the appellate authority.
No, that is
Paragraph
not.
8, paragraph 855 page.
Yes.
Therefore, notice.
Annexure 3.
Therefore, notice was issued to Srimati Minati Mishra,
Mr.
ex-PIO.
Yes.
Please wait.
Annexure 3. Annexure 3. Just to make it. थोड़ा सीधा के बहुत All the headmasters will be distressed. And it is mentioned in this. That's art and this one, so.
First standard.
And the.
Senior was teacher of your school. So who was the public information officer on the date when the application was filed?
Srimati Bonani Parnay.
Whether this, please.
So Srimati Meenakshi Mishra, he was the ex-PI, because that particular time was the PI.
It has been mentioned also, senior most so and so, he has to act as the PIO and headmistress, humans headmistress, he has to act as the first applicant.
Decline to receive. You are representing whom?
I'm representing State Information Commission. But before merit up. My lord, if your lordship permit, may I submit one thing, my lord? My lord, it is an inter-court appeal. Intra-court appeal.
Yes.
It is from the beginning, I'm submitting that is not maintainable. Because honorable single judge, he decided the matter and exercised his jurisdiction under Article 227.
This intra-court appeal is not maintainable.
Not maintainable, because lot of judgments are there, my lord. Because, see, PIO passed some order, then he filed first appeal, then subsequently complaint case, then he challenged this order in the writ. So it is an appeal, Lordship, 100.
For the first time, this kind of submission.
No, my lord, Lordship, come to see the judgment. This is the intra-court appeal, because what happened, my lord, here is a case, a writ application was heard under Article 227. 227 is just supervisory jurisdiction.
The application was filed under Article 227.
226 and 227 he filed, but in fact, honorable single judge, they heard the matter and exercised his jurisdiction under Article 227. Because under supervisory power, my lord, he exercised his jurisdiction.
Oh.
What happened? In this background of this case like this, my lord, PIO, he passed order for supply of the information, then subsequently challenged that order in the first appellate authority. Then challenged that order, against that order, he challenged before the State Information Commission.
From where you are making your submissions?
No, yes, then State
Mr. Counsel, from where you are making your submissions, come to the order.
yes. In the merit of the case, Lordship, that he has not appeared despite notice, that's the other thing. But maintainable point, because his judgments are there, last time argued that case, that is well. Otherwise, not authorized.
Mr. Counsel, on what basis you are saying that there was an order passed by the PIO and thereafter appeal was preferred before the first appellate authority, and thereafter an appeal was preferred before the second appellate authority, and thereafter the matter came to the writ court? Where from you are making the submission? Please come to the impugned order. Why everyone is arguing in here?
PIO,
Mr. Das.
it's a case 55. PIO,
The case of the complainant is that PIO did not respond.
that's not.
That is why he filed the complaint.
Yes.
Okay. And in the complaint petition, that order was passed and that was challenged before the honorable single judge, right?
It's lekha in it, but after PIO, then the provision is to file first appellate authority, the next authority to file this case. 19(1). He cannot go to the Information Commission. That was my submission.
Because the first appellate authority is the very person against whom you are raising the grievance. That is why perhaps he thought it proper to file the complaint before the.
That's correct, but,
Right.
but the provision is, my lord, before, after the order passed by the PIO, then you have to prefer first appeal. That is my humble submission, my lord.
And something wrong has been committed by the complainant, making some sort of statement that the PIO is the headmistress in charge. But they are two different persons. PIO is the senior most trained graduate teacher. Headmistress is the first appellate authority, but you give an impression to the information officer that it is the very same person. That is why it was accepted and that order was passed and penalty was imposed.
So in the merit of the case, my lord, in fact, despite notices, it didn't appear. That is why commission.
Sir, if someone does not appear despite notices, therefore you will punish him.
Well, because he obstructed associate section 20. Let's see section 20. 2021. May I permit you to read, man?
This is illegal. Which says.
We are pushing. That you said, Your Honor. The patent intra-court appeal has been preferred by the appellant putting to challenge an order passed by the learned single judge dated
6/7/23.
6/7/23 in WPC number 20436 of 2023, whereby the learned single judge declined to interfere with an order dated 24/4/2023 passed by the State Information Commissioner in complaint case number 96 of 2022, whereby, apparently in exercise of power under section 20 of the Right to Information Act 2005, the Information Commissioner, the Information Commission, State Information Commission, imposed penalty of 15,000 upon the petitioner.
Right.
Full stop. Next. The facts are not much in dispute. Full stop. The petitioner at the relevant point of time was working as the principal in charge, headmistress of the Girls' High School, Unit Bhubaneswar.
Unit 4.
Unit 4 Bhubaneswar. First off, in terms of a decision of the state government, the senior most teacher of a school has been designated as public information officer, whereas the whereas the principals of such a school, headmasters,
Public headmistress.
headmaster slash mistress as the first appellate authority. Stop. The opposite party member, who is for the private opposite? Oh, let notice go. No one is appearing. Issue notice.
Notice saying. Notice.
All right. Let notice go. Party. Complainant has been made a party. No.
That's not nothing.
Done counsel for what is this? In the writ proceeding also, you had not impeded him.
I don't know. Copy number 2 is Mr. Prabhat Kumar Satpathy is the complainant. Right?
Yes, sir. Copy number 2. Hearing method.
Notice.
Respond number 2.
Speed post. Yes.
So that is the IA.
What I
For
forget.
staying a person of the.
Item number 2. Number 2, my lord. Noting is affidavit relating to filing of the affidavit. I have filed today the affidavit. I have filed today before the registry, my lord. And in this case, Mr. Mishra, there is a direction on 22/8/2022. Serve a copy on Mr. Mishra, who is appearing for the corporation, my lord. I have served the copy on him on 24/8/2023.
So what do you want?
My lord, he has not appeared and his name is not reflected in the cause list.
So does he have authority to receive notice, to accept notice?
Yes, my lord, as per the direction of this Honorable Court, I have served on him because he is appearing for the corporation. Normally, he is appearing for the corporation.
It depends on his client,
Yes, ma'am.
whether he engages the client engages him or not.
Yes, yes.
If you notice, then
Yes, ma'am.
if you notice. Yes,
I will take my speed post. Ma'am. I will take notice by speed post. Ma'am.
speed post also. 2 weeks. Requisites.
Item 3.
6 weeks rule written notice.
Your Lordship, on behalf of Mr. Debaranjan Mahapatra, Your Lordship may taken up next week, Your Lordship.
As requested on behalf of the petitioner list. What is this about?
This is about OGLS Act, Your Lordship. I have not gone through this fact.
All
Your Lordship.
As it will list this matter on next Friday.
Item number 4.
Oblige.
May I please, your lordship. I mean, busy, your lordship. Item 4.
Please.
Your lordship, the matter has been already infructuous, your lordship. Kindly may be permitted to withdraw, your lordship.
Withdraw effectus.
Item number 5.
Please, your lordship.
Challenge the order of the Honorable Single Judge. I have challenged the order dated 19/12/2023 of the Honorable Single Judge passed in WPC OAC now 322 of the 2013, my lord. in which the writ petition of the petitioner has been dismissed without taking into account the provisions of law as well as the statutory provision, my lord. This appellant was is child development project officer at Gudvela in the Balangir district. He took leave.
Just a minute. The Odisha service phone.
Well, she took leave on
Just a minute. So you have been removed
service.
under section 72, rule 72(2). So what is wrong?
That I'm coming to that point of law, my lord. She took leave till 14/4/1996.
No, whether there is any procedural irregularity.
Irregular, procedure irregular.
Oh, what is that?
The inquiry officer held that I am not in unauthorized leave, my lord. The inquiry report will also can come to page 63. Since the DO had sent application from time to time to the 63 on middle subpara, my lord. I'm coming to the finding, my lord, of the inquiry officer. Just first para, second para, 2 line, my lord.
Just a minute. Page 63.
63, page 63. Inquiry report is at annexure 7 at page 61, my lord.
So there.
No, my lord, that 61 page of the writ petition, my lord. I've annexed the entire writ petition, my lord. Annexure 7 to the writ petition. That is at page 61.
Page 61
Yes,
of the writ petition.
yes.
Let us see.
That was at annexed as annexure 7 to the writ petition inquiry.
Okay. 61 is annexure 8.
My lord.
8.
Annexure
Yes.
8.
No.
So where is the report of the inquiring authority?
That is annexure 7. I have annexed the writ petition. Your lordship, that writ petition annexure 1 at page 23.
Yes. So what is the finding?
Finding that since DO has sent applications from time to time to sub-collector Balangir, perhaps the term of unauthorized absence may not be proved. Unauthorized absence was not proved.
Which paragraph, please show us that?
My lord, that
On the report of the inquiring officer.
that paragraph, second paragraph at page 63, inquiry report, internal inquiry page report 3, page 3.
63.
63 of the writ appeal.
63, as it appears, page 63, that is annexure 10.
Annexure 10.
You have put number of
You can find it from page 57.
57.
Yes. But that is not properly marked.
Single page has been marked twice,
Yes.
thrice like this way.
Yes, my lord, there.
Not page, properly page marked.
That is the problem. Yes, 57, that is the inquiry report.
Inquiry report, my lord. Then first
Yes,
page,
just a minute.
the third page.
Where is that finding?
Finding the third page of the inquiry report, first paragraph, second paragraph, 2 lines, my lord, they are finding. Since the DO has sent applications from time to time to sub-collector Balangir, who was the immediate authority, Perhaps the term of unauthorized absence may not be proved. Then next page, my lord, recommendation of the inquiry officer. At page, next page, second paragraph.
No, the inquiring authority has no authority to recommend anything.
Then this inquiry report was
Beyond his jurisdiction.
my lord, the inquiry report was given to me for filing the show cause. I filed the show cause. Then the personal hearing was given to me. After that, the inquiry officer, the disciplinary authority disagreed with the inquiry report without assigning any reason as to why he disagreed with the inquiry report, my lord. No reason has been assigned. Your lawsuit can come to Annexure 11 to the writ petition. To the writ petition number. I ban. Placing that, my lord, that last paragraph.
Exceptional as an exceptional case when like to consider.
Odisha government
Classification control appeal.
letter date 29, 2011, my lord. I am placing that one. Now, therefore, government after careful consideration of an explanation, findings of the inquiry officer, reply to first show cause notice and fact stated during the personal hearing, did not find any exceptional circumstances to accept the prayer of Srimati Ball, and for which government disagree with the findings of the inquiry officer as stated above, and have decided to remove her from the service as per Rule 72, Sub-Rule 2 of the Odisha Service Code, my lord. My lord, your losses can come to Rule 15 of the Odisha Civil Service CCA Rules 1962.
Just a minute.
15 Sub-Rule 10, my lord. Your losses can come to that. Sub-Rule 10, B, my lord. On receipt of the
Just a minute.
Yes, so there is your submission that notes of disagreement were not supplied to you.
No, my lord, no reason has been assigned as to why the disciplinary authority disagreed with the report of the inquiry officer, and thereafter, after decision, the inquiry officer should give, the disciplinary authority should give you a finding and call for the explanation. And after giving explanation,
Yes, so
might
is
give a
what he
finding.
Well,
He appears to be correct in his submission.
no, man. It may draw my lord's notice that inquiry report. You'll also may see that inquiry report. I'll draw my lord's notice to page 60.
Yes.
Lord's may the provision that this is the inquiry.
No, whether the inquiry report according to you was in her favor, in the appellant's favor, or
Not on in her favor. my
against.
lord. Not in her favor. You'll also may see that what I am submitting, my lord.
Right.
You'll also may see page 60.
Page 60.
My lord.
Please.
The provision of statutory rules and acts which referred to in the proceeding cannot be ignored. As per Odisha Service Code Rule 72(2) clearly indicates that a government servant who remains absent on duty for a continuous period of 5 years shall be removed from service after following. This is the finding of here she remained
that she was absent for more than 5 years.
Yes, ma'am.
So
And
therefore, no inquiry was required to be
no,
conducted.
thereafter inquiry has been conducted. Inquiry has been conducted and this is the inquiry report.
What is the inquiry report?
This, the inquiry officer says in view of the rule 72(2), she can be removed from service. And may I read my rule 72?
No, where is the finding?
That this,
Where is the finding that amounts to misconduct? See, he is referring to one finding of the inquiry officer. Since DO has sent applications from time to time, perhaps the term unauthorized absence may not be proved.
but unauthorized absent may not be. Rule 72(2) says if one is absent, not unauthorizedly, simply if one is absent more than 5 years, he is to be removed from service.
Rule 72.
Rule, yes, ma'am. That I'm.
Mr. Counsel, that provision is there,
Yes, ma'am.
but it adds that order of removal shall be passed in accordance with the provisions under CCS rules.
Inquiry has been conducted. Proceeding, charge has been framed. Period the Odisha Service Code Rule 72(2), which is subsequently indicates that unless government in view of the exceptions of the case otherwise return be removed from service after following the so and so. That has been quoted from Rule 72(2). May I read my lord, Rule 72(2), my lord?
That's what we have seen.
Where a government servant does not resume duty after remaining on leave for continuous period of 5 years, or where government servant after expiry of his leave remains absent from duty otherwise than on current or on account of suspension period, which together with the period of the leave granted to me exceeds 5 years, he shall, unless in view of the exceptions of the case otherwise determined, be removed from service. My lord, inquiry officer has recommended the government may consider as an exceptional case. That
You now come to your order.
my lord.
29/2011.
Yes, ma'am. Page 64, annexure 11.
Yes.
At the recommendation of the inquiry officer regarding to treat it as an exceptional case, that was not accepted. Also got recommendation of the inquiry officer at page 60. He recommended to treat it as an exceptional case. That was not accepted.
No, please come to the
Page
order.
64, annexure 11.
Whereas the inquiring officer submitted the inquiry report on 6/5/2010, whereas was directed by so and so for personal hearing.
Well,
So what consideration is there?
consider after submission of
There is
the,
no consideration.
no, after submission of the inquiry report, she was given a personal hearing. The inquiry officer submitted the inquiry report as the disciplinary inquiry officer. You are not the disciplinary authority.
Oh, just see the last part of the sentence.
Whereas after hearing her in person,
Now therefore,
yes, Mala, after hearing in person and perusing the relevant records, the commissioner cum secretary has been pleased to reject her subsequent response to the inquiry as it does not have any merit. Now, therefore, government, after careful consideration of her explanation, findings of the inquiry officer, replied to the first show cause notice, in fact stated during personal hearing, did not find any exceptional circumstances to accept the prayer of Srimati Bora, and for which government disagreed with the findings of the inquiry officer.
disagree with the finding. Which finding?
That finding page 60 I have shown, my lords.
That is not a finding.
But that is the report. He is relying that report.
No, he is relying the report, but finding is different. There is difference between finding and recommendation, Mr. Counsel.
And this is the, you'll also may see that it starts from page 57. You'll also be saying that finding that it starts from page 57. That is the report that.
Followed the thing B.
It's a very simple principle of service jurisprudence that if the government or if the appointing authority does not agree with the inquiry report favorable to the delinquent, the appointing authority has a duty to issue notes of disagreement to the delinquent, seeking his opinion as to why the appointing authority should not disagree with the finding. An opportunity has to be given, even without any provision under the classification control appeal rules. This is the fundamental thing.
Your Lordship, then Annexure 8, page 61.
Absolutely unnecessary.
After inquiry report, Your Lordship, inquiry report, Your Lordship has seen that Annexure 7, page 60. Thereafter, he was given an opportunity to have a say on that findings.
Mister, you had to prepare a dissenting note.
Yes, madam.
The appointing authority had a duty to issue notes of his disagreement.
Yes, madam.
That was required to be done. That has not been done.
I will take instruction on that part only.
Not take instruction.
From the government.
As requested on behalf of the state. Issue notice. And AGA receives, accepts notice on behalf of the opposite parties. This matter on 4 weeks for instructions.
Madam.
And second notice is required before imposing penalty. That is 15 10.
It has been decided.
That has not been done in this case.
By Honorable Supreme Court. When once the Islam operator disagrees.
Mr. The clause B
assigned the region.
Clause B is there because of the Supreme Court's decisions.
Yes, ma'am.
You will also fix it while on.
Item number 6.
And let that my lord.
22nd.
Yes.
Next week.
Item number 6.
May I please your lordships. Order passed by the Honorable Judge of this Honorable Court dated 24 January 2024 is assembled before my lords. That originally the petitioner along with some other persons have approved this Honorable Court in writ petition, seeking relief for that without notice or without giving the opportunity of hearing, they shall not be evicted from the land in question. The Honorable Single Judge, while hearing the matter, passed the order at page 14. The lordships have a glance paragraph 7. In the result, the writ petition stand dismissed. However, with the direction to the petitioner to vacate the scheduled plots within 4 weeks from today, failing which necessary action shall be followed at the instance of opinion number 4. However, it is directed that there shall be no coercive action against the petition till such time the plots are vacated by them within the above stipulated.
Similar matter came, I think, yes.
Matter the lordships are disposed of, extending 1 month more time for.
I respectfully submission before. What is that number? I just 1 day or 2 days back.
Yes.
Is very.
Wednesday.
Where is that?
Just the same Honorable Single Judge.
Right.
You vacate it.
My lord.
Vacate the land.
My lord, I have been given an opportunity to say my say.
Can you tell me that number, the number
My lord,
of that other case?
that I will find out and give it to
Okay.
court master. There are 4 or 5 cases.
Right, that they will dispose.
1 month time extended.
Right, that one.
1 month.
Item 7.
May I please your lordship. The order passed on 13 February 2024, passed in writ petition that is under Annexure 7 is assembled, my lord. Page 25.
Page.
Page 25, my lord, the impugned order. Running over at page 27, my lord.
So what is wrong with the order?
Wrong is, my lord, that under section 91(2) of the ODA, I am submitting, my lord.
Yeah.
Under section 91, subsection 2 of the ODA Act speaks that if there is an order, that order need to be preferred in the appeal or challenged in the appeal. But here my challenging is annexure 6 LRC by the glance at page 24. This letter has been communicated by the Omni.
Just a minute.
May I read, my lord, subsection 2 of section 91? First.
So if you are just challenging the notice,
Yes, ma'am.
then you should have responded to the notice.
Yes, my lord. My respectful submission is that before issuing a notice,
You may be right that you cannot prefer an appeal. But you should have responded to the notice.
you'll also have a glance above just section of subsection 2, the proviso of 1. Provided that no such order shall be made unless the owner of the person concerned has been given reasonable opportunity to
Whether any order has been passed,
No, I don't know, my lord.
then you should have replied to that notice.
Yes, my lord. I may be permitted to give him a complaint, ask me to file a show cause, give him an opportunity of hearing, then order be passed, whatever order by the court.
This is the order which you obtained.
I have no order, my lord. This Omnium has served this notice to verify my building. My submission is let me serve a copy of the complaint.
You could have filed a review application.
So unless or until
You could have preferred a review application.
my lord, I may file a review application, but the opportunity must be given, my lord. Natural just not being followed.
Your challenge was to the notice issued, received from the Amin,
My lord,
that is annexure 6 of that.
my lord, my lord.
Where is that?
That is at page 24, my lord.
Of this writ appeal?
My lord, or the writ appeal, my lord. Writ appeal as well as the writ petition.
So please come to that notice which you have received from
Yes,
the
my lord.
Amin.
Page 24, writ appeal, my lord.
What has been mentioned here?
With reference to the subjected cited above, one complaint has been received from Odia Court.
Okay.
BMC head number so and so, that you have undertaken unauthorized construction over plot number 18 by 1182, Mauja Dumduma district Khurda. So verification will be held on 16/2/2024 at
So
4
we
p.m.
will modify the order and we will give you liberty to respond to this notice.
Given the opportunity of hearing, my lord.
Once you respond to the notice, that is the hearing. In the present intra-court appeal, the petitioner has, the appellant has put to challenge an order dated 13/2/2023 passed by 24 passed in WPC number 3251 of 2024. So stop. The appellant had filed the aforesaid writ application challenging a notice received from the Amin of ODA Court, Bhubaneswar Municipal Corporation, bracketed BMC. Stop. Then single judge noticing section 91 bracketed 2 of the Odisha Development Authorities Act 1982 relegated the appellant to the forum of appeal. Stop. Learned counsel appearing on behalf of the appellant has submitted that there was no order passed under section 90, under subsection 1 of section 91 of the Act, and therefore he did not have, and therefore it could not be said that the petitioner had remedy of appeal under subsection 2 of section 91 of the said Act. Said Act, since only notice issued by the Amin was under challenge. Stop. We have yes for the estate. There was no order.
This is a Commissioner of Municipal Corporation. Commissioner of Bhubaneswar Municipal Corporation, that we are not appearing for municipal commissioner. They are separate council. DMC.
Notice. We find forth in the submission advanced on behalf of the appellants. Issue notice.
They have a panel of counsel or what?
They have panel of councils. Mr. Mahath is also appearing. I'll intimate Mr. Mahath.
Okay.
For the previous 2 weeks, let's after 6 weeks. So
DK Mahath is appearing. I'll intimate.
GA is the.
Hey.
Mr. Mahathim.
Devakanta Mahath. And the
He was present here, he has just left. He must be outside, just so that it can be sorted out. And if he accepts notice and say agrees for the disposal, that can be also done. Is he available?
No, sir. In fact, Mr. Mahathir is not there, but one thing, under the Development Authority Act, Bhubaneswar Development Authority is the authority to issue a notice under section 91. It's also municipal corporation law. It is not being given. No, you can dispose of the granting.
But we have to record the presence of that.
Yes, presence not so. Those who are record Mr. Mahathir's presence, I can. No, I thought of it.
All right, we will pass order after.
Yeah.
Just ask him.
Mr. Mahath's presence.
On behalf of the appellant, that in the absence of any order having been passed under subsection 1 of section 91 of the ODA Act, there was no question of the petitioner appellant availing remedy of appeal under subsection 2 thereof. So stop. The fact, however, remains that the appellant had approached this court by filing the petition putting to challenge a notice issued by notice dated 9/2/2020.
24, sir.
24 issue. No,
Yes, sir.
no, no, 9.
Yes, 29, 1922. Give him a copy, mister. Please give him copy.
What is the date of Annexure 6?
9/2/2024.
24.
9/2/2024.
13 is the officer. Everything is going on.
First. 2024. Requiring the petitioner appellant to appear before the Amin for verification of unauthorized
Please
construction
hand over that notice, just let him see that.
of plot. And the appellant has admittedly not responded to said notice, comma, we modify the order passed by the single judge and dispose of the writ petition and the present appeal with a liberty to the petitioner to appear before the Amin. Yes. Appear before the Amin ODA court BMC on, can we give any date?
Yes, we can.
On
On which date you are within 1 week? Or a particular date you want, so that you can.
Time may be given.
we are giving a date.
Your lordship, I need that,
Today is 22nd.
Yes, today is 22nd, so it can be in the March 4th onwards, that any date.
March 6th. 6th March. 6th March at 4 p.m. Stop. We make it clear that if he appears before the Amin and demands for, if the appellant appears before the Amin and demands for a copy of the complaint.
that will be ODA court. Amin doesn't have any.
Amin ODA court.
Yes, ma'am.
The notice has been issued from the.
On receipt of a complaint from the ODA court, Amin served the notice.
Okay.
ODA court.
My lord.
The date, time of the notice. The appellant ODA court and demands for supply of the complaint based on which the said notice came to be issued, comma, the concerned authority shall be under obligation to supply the same to the appellant. Stop. This application. This appeal stands disposed of accordingly.
So, Mr. Park is present.
Notice, notice. Mr. Mohanty, on the court's request, Mr. Mohanty, learned counsel who generally appears on behalf of
Bhubaneswar Municipal Corporation.
BMC, has accepted notice on behalf of the corporation.
Lordship may kindly direct that we will produce this copy of the order before the concerned.
The last one, the applicant shall be required to produce a copy of the present order before
OTA code for
the ODA code for compliance.
After the minute of the hearing may be given by the audio.
That will be given. to you.
that goes with it.
Item number 8.
May I please, Your Lordship. Your Lordship, in item number 8, the demand come show cause notice dated 26/12/2023 has been challenged, which was passed under section 73 of the CGST Act, Your Lordship. Your Lordship, it has been challenged on the ground that it has been passed by an authority who lacks jurisdiction, Your Lordship. Your Lordship, as per the section 73 of the CGST Act, it is to be passed by a proper officer. And as per clause 91 under section 2 of the Act, Your Lordship, proper officer has been defined. Proper officer in relation to any function to be performed under this Act means the commissioner or the officer of the central tax who is assigned that function by the commissioner in the board. Your Lordship, even if the entire notice is perused, Your Lordship, neither it has been mentioned anywhere, nor does the authority nor it can be established that the authority is in fact the proper officer, Your Lordship. And since it has not been issued.
According to this, your submission that the superintendent is not the competent authority.
No, Your Lordship. It has to be issued by a proper officer, Your Lordship, as per clause 91, section 2, Your Lordship.
Section?
Section 2, clause 91, Your Lordship.
No, this notice has been issued under which provision?
73, Your Lordship.
73.
Clause 2, subsection 2, Your Lordship.
Which is defined under 291.
So what is the definition? Proper officer in relation to any function to be performed under this act means commissioner.
Yes, Your Lordship. Commissioner or the officer of the central tax who is assigned that function by the commissioner in the board, Your Lordship. Your Lordship, on perusal of the entire notice, Your Lordship, the designation of the authority does not specify that.
No, designation is there. Superintendent.
Yes, Your Lordship.
So is this your case that the superintendent has not been authorized in terms of subsection 91 of section 12?
On perusal of the notice, Your Lordship.
No. You will have to take a plea.
Your Lordship, there is another ground, if Your Lordship may allow me to submit. Your Lordship, as per section 73, where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized for any reason other than the reason of fraud. Your Lordship, on perusal of the notice, there is no specific reason has been assigned as
Reply to that notice.
But Your Lordship, until and unless since the allegations are vague, Your Lordship, I am.
You can say in your reply that the allegations are vague.
Until I know the allegation, Your Lordship, I cannot defend my case to
you can say that the allegations are not clear.
But it lacks the basic ingredients of the.
Can tell them. Can reply. All right.
Your Lordship, my contention is that it is
Your
against
contention,
principle
if you can file an affidavit, then the officer who has issued the so-called notice does not have the authority and has not been authorized under subsection 91 of section 2. You may have a case, but it's not your case.
Yes, Your Lordship. My case is only on perusal
And
of
the best way is to respond to the notice. All
obliged.
right. We're in counsel for the petitioner. Some argument seeks permission to withdraw this writ application with a liberty to respond to the so-called notice dated 26/12/2023, which is under challenge in this matter. So by the said notice, the petitioner was asked to submit his reply within
30 days.
Within 30 days of keeping in mind the fact that the petitioner approached this court by making this application under Article 226 of the Constitution of India. We observe that if the petitioner submits his response to the said so-called notice within 15 days from today, the proper officer, the competent authority shall consider the same and shall not reject the reply on the ground of delay.
Yes. Absence will be noted below. So far as 2 and 3.
Stands disposed of. Yes.
Item 9.
Item 9, I pray for next week, my lord.
As requested next week.
Item 10.
My lord, Mr. Biraja Prasanna Das has some personal difficulty. Kindly be taken up next week.
Next week as requested.
Item 11.
His short here is, Lord, I am a contractor, Lord. I have completed the work. And I, Lord, asked, my time was extended, but without claim, without declining or accepting claim of exclusion price. Lord, my refund is pending annexure 1 since long. That may be disposed within a certain time. That's sort of paper.
You can pursue.
Annexure 1, Lord.
That you may pursue.
Pending before the OP4. Pending before the opposite party now 4.
Run counsel for the petitioner after some argument submits that it would suffice if this court directs the superintending engineer Ringali left.
Ringali Lift Canal Division.
The Ringali Lift Canal.
Canal Division. Jarimal Kamakya Nagar
Canal Division. Jiramali. Opposite party? 4. To dispose of the petitioner's representation, which is pending since 6/6/2022. So next, considering the nature of dispute raised in the present writ application, it stands disposed of with an observation that let the said representation be disposed of, comma, if not already disposed of, comma, expeditiously, preferably within a period of 2 months from the date of receipt of the production of a copy of this order. We have expressed no opinion on the merits of the case.
Item 12.
We have expressed no opinion.
May it please your lordships, the petitioner before your lordships is an trust engaged in charitable activities. Lordship will be pleased to.
Just which item, sir?
Sir, I am in item 12.
12.
Yeah. Lordship will kindly see the trust deed that starts from 23. The object Lordship will find at page 25. My lords, the petitioner trust has also been granted registration certificate by the Commissioner of Income Tax under section 12A that your lordship will kindly see at annexer 8, page 107, matters.
Income tax.
Yes. 12A, once a society has been granted registration certificate by the commissioner, who after inquiry finds that it is actually in the activity rendering public charitable, which is also under section 215, then the income of the trust is exempted. Now, my lords, you may see it, section 12A and 12AA. 12A. I file a return, my lord, the trust file a return on annexure 1, page 18, my lords. Then, my lords, it was processed. 12A. Conditions for applicability of section 11. Section 11 says about the exemption of income, my lords. Then it is not it is a charitable institution that is also admitted by the department, no dispute about that. Now, my lords, the dispute lies in the fact, my lords, after the return was filed, it was processed by the CPC, that is Central Processing Center, Bengaluru. Now, what, my lord, the Bengaluru, the additional director did, my lords, he disallowed all the expenses, and lordship will kindly see that is annexure 6 at page 96. He entirely treated the receipts to be income, my lords. Now, all the, my lords, the fundamental of the Income Tax Act is that, my lords, all receipts are not income, but all income are receipts. Now, my lords, I file an application for rectification of the mistake, that is annexure 7 at page 102. Under section 154, I filed an application specifically requesting the authority to kindly grant me an opportunity of hearing. My lords, that was also rejected. My application was also rejected.
Yes.
Then, my lords, rejection order is annexure 9 at page 108, against which I prefer an appeal. Appeal is pending, my lords. That is, lords will find annexure 1 is my appeal filed on 25th of 11/2020. 109 it starts, and the proper page I specifically requested to the commissioner exemption that I may kindly be given an opportunity of hearing. Now, the Commissioner of Income Tax exemption Hyderabad, lords will kindly see annex page 113, para 8.4. Politely, it is requested to grant a personal hearing at the time of disposal of the stay application towards complete stay of the disputed demand
which may kindly be intimated to us in advance. But in spite of that, my lords, the Commissioner of Income Tax, lordship, that order of the Commissioner of Income Tax.
Is it obligatory for the Commissioner of Income Tax to
My lords,
give you personal hearing
my
if
lords,
you make a request?
my lords, it is obligatory in the sense, my lords.
Is there any statute?
Statute, my lords, of course, it is not there in that.
All right.
All right, my lords.
So why the appeal is pending?
Why I am challenging this?
Why the appeal is pending for last 4 years?
I don't know, my lords. I have given series of intimations, series of requests that a lordship will see.
Seek instructions on this point only.
Yes,
Your Lordship,
Why?
he has challenged the demand, stay of demand, which has,
Mister, there is something which is pending before you
Lordship.
for last 4 years. So if you can dispose that off, the
issue will be over, my lords.
Your Lordship, when we file an appeal, within a month, we have to file a stay petition. Then stay will be granted accordingly. In similar case, he has filed appeal in
different thing. Stay
2020 has filed an appeal. Now he had filed a stay petition. Then we had a recovery of demand. Then he filed a stay petition. And in the stay petition,
is this your case that the appeal is not maintainable?
no,
Is this your submission that appeal cannot be disposed of?
yeah, appeal can be disposed
Then
of.
do it.
I'll take inst-
It has been argued on behalf of the petitioner, comma, inter alia, comma, that an appeal. White number?
My lords,
Annexure 1.
Annex 1 at page 18, my lords.
No, it's number, etc.
Yes, your lordship is correct. I'm giving you
In
12, 12A, 12B, the notices which are issued. I have complied those notices by the
what
industrial.
is that appeal number has been given?
I am just giving it.
No, no, yeah, there are.
107. Author.
Page 18.
Page 18, your Lordship, acknowledgement number in the top of the right hand side.
Yes. Page 18, Annex 1.
That acknowledgement number is given.
Yes.
Yes.
That is the appeal number.
Yeah.
Is there-
Now, appeal is separate and maybe in this due to faceless may issue a separate notice and have a appeal, different appeal number. I have to verify your Lordship. But once you file an appeal, they
Appeal number is also will carry, I am giving you. You have not read. Appeal number NFAC oblique 2007.
Appeal number NF.
National Faceless.
What is that mentioned? It's
That
mentioned in
mentioned Annex 121. Annex at 12 by A.
Appeal number is there.
just a minute.
Sorry, another.
121.
Yes. NFAC.
Just,
the part.
please.
Yes. 100217448. So we kindly see from the top, the third one. Just before assessment year 1819.
All right.
My lord, got it? Yes.
Appeal number NFAC / 2017. Oh. -18. Is this the appeal number?
My lords, NFAC.
This is notice.
No, my lords. Appeal number is given.
Number
Yes, sir.
Okay.
It is
1002748.
in
assessment year has been given down.
lodged on 24/1/2022.
Yes.
My lords, I have
File on.
given, my lords, series of notices came and your loss will see.
So when was the appeal filed? Can
Appeal was filed on 25/11/2020.
But it is mentioned in 24/1/2022.
No.
The number which you are reflecting,
Hmm.
just above that, please see. Or whether it is the notice dated or appeal
No,
dated.
it is notice.
Notice dated.
Because
in
Okay.
November 2022, before The Commissioner Income.
National Faceless Appeal Center. Lordship will knows that after 2021, when the Finance Act came, it divided faceless assessment under section 144B and also faceless appeal centers. That was also there. So once you file the appeal directly to Delhi, they will distribute to whom the appellate authority, you cannot know. The assessor will not be able to know which appellate authority decides.
Appellate authority. Since November, or National Faceless Appeal Center. Before the appellate authority since November 2020. Stop. Which? Is pending before the national filed before the National Faceless Appeal Center bracketed NFAC since November 2020. Against which order?
Against the order of rejection under
Against
section,
the-
that is Annexure 7 balance.
Against
Sorry, section 9. I'm
Annexure
extremely
9.
sorry. Annexure 9, page 108, where my application under section 154 for rectification was rejected and I filed an appeal under Annexure 1.
Annexure 9.
Annexure 9 is the impugned, which was impugned before the appellate authority at page 108.
Against an order dated
30th of October 2020.
30/10/2020. Passed by
the National Faceless Appellates, National Faceless Center. That is CPC. Sorry, I'm sorry. Sorry. That is my lord's Centralized Processing Center, CPC, Bengaluru.
Central.
CPC, Central Processing Center. That is a system, my lords.
108 centralized system.
Lots you will see page 108, Annexure 9. Rejection of request for rectification under section 154 of the IT Act. Please refer to the rectification.
Centralized Processing Center. So stop. Center,
Income Tax Department.
Stop.
That just was
Bangalore.
Bengaluru.
Stop. Next. This is matter on 8 weeks. So as to enable and call for the Income Tax Department to seek instructions and inform this court as to within what period the petitioner's appeal pending since November 2020 shall be disposed of finally. Yes.
Your Lordship, a notice was issued in 2021. They are regularly issuing the notice and they were complying with it. Due to national faceless, the system, you have to upload the return. You have to reply. Yeah, nobody know who is going to complete the assessment.
Complete the appeal.
Appeal.
Yes.
So, your Lordship, the process, when a notice is being
You can take a stand before this court that no one knows when the appeal shall be disposed of.
Right.
You can say that it is difficult for any authority under the government to tell as to what time will it take for disposal of appeal. All right, take this stand because of the system which you have. All right.
There is an interim application, my lords. I have already paid more than 60% of the demanded tax, which means
All right, let it come after 8 weeks. It has
That is, if they will take coercive action.
What chaos. Your appeal is pending since 2020. For this court in 2024.
But I'm not saying about allowing. I'm saying, my lords, lordship may say that no coercive action. Because once, I'll cite one judgment of the Telangana High Court.
You have already deposited 60% of the limit.
Contribution to be state, man.
Your lordship has already only paid 19 lakhs 00570 only.
Given a
Out of the
read the brief.
which is in the page number 21.
I have given,
And we have issued, your lordship, when you file an appeal, there is instruction by the department. You have to deposit 15%, that was extended to 20%.
that came to be
circular.
that came to be considered by the Supreme Court in LG Illa.
Let it come after 8 weeks.
After
8 weeks. 8 weeks.
8 weeks. Well, at least some interim protection may kindly be given.
No. Next date we assure you. On the next date we assure you will pass some order.
Well,
Interim order if required.
then that application may lie over.
We are not disposing of that.
Well,
We'll just come back.
Which is a requirement from the state authorities. Page 15 may kindly be seen. 1-5.
Yes.
15. But please, this is the order of grant of NOC by the authorities for 60 seats. The tabular form may can see my institution, Netaji College of Nursing, MSc Nursing course. We have been allowed for 60 seats. Intake capacity. Accordingly, my lord, the Health University, Odisha University of Health Sciences, in Annexure 3, page 17, my lord, has also granted affiliation for 60 seats, page 17. As per the procedure, my lord, the concerned Chief District Medical Officer is to give also a consent to allow these 60 students to participate in the training program there. That is at Annexure 4, my lord, page 18. It was also done. For 60 students, they have also given the clearance. So accordingly, in Annexure 5, we have given the admission. We have taken admission to 60 students. But all of a sudden, my lord, without any reason, my lord, now Annexure 6 has been issued by the director. My lord, kindly turn to page 24. Last page of the page. Relevant page, kindly see my lord, page 24. Now our intake capacity has been brought down to 25 from 60. When we have done everything, it is completed. Students have been admitted. Classes have started. Now, in their website, it has been published. Now our seats have been reduced to 25. Serial number 23, last, page 24, last serial. Netaji College, the heading is number of seats. Now, they have said it is 25. In the top, my lord, that is why advance against the
Which one?
my lord, last one. 23 serial.
23 years.
Netaji, it is 1 to 3rd column, my lord, number of seats.
Okay.
25. My lord, now we have already taken admission of 60 students. They are prosecuting.
Now, what is 25 community health nursing? 5 nurses. 5 medical.
That is the breakup, my lord.
That is the breakup.
Breakup of these two. We have taken 60. We have allowed 60 seats. We have taken admission of 60 students. Now they have brought it down to 25. That is difficulty for us, my lord. Now, to whom we will reduce, my lord? Already we have 60 students. That is my difficulty, my lord.
This is for academic session 2024.
Same thing.
No, but what is this? What is this page? This page is part of what?
This they are saying now you have to go for a council for admission only for these 25 students. But already we have taken with their authority permission, we have taken admission 60 students in on roll. Our permission, application, everything granted for this session 23-24. Accordingly, we have accepted the students in MSc nursing course.
So have they asked you to remove students or?
This is everything is now online. We cannot.
You could have told them that this is a mistake.
A number of institutions, madam. It is not even me. It is a good number. All the institutions throughout the state, they have been notified here. This is their strength.
All right.
But now we will be in difficulty.
Where is the question of you being in difficulty?
Because we have 60 students, now they have granted 25.
Mister, we wanted to know. This is just a list which has been published by the state government. We wanted to know what this page 24 is part of what? There is a list of private nursing institutions for academic session 2023-24.
Yes.
You could go to them.
Yes, I have.
Tell them, my lord, this is wrong. You are straightway coming to the High Court.
No, my lord, I categorically stated we have been to them. They say whatever the list we have published for each institution, where is that? There is no communication to the report.
We don't know. We don't know. They have just issued a list and you have come to the High Court. You could have told them that there is a mistake committed by you. This is what was sanctioned by the state government.
The same authority, madam.
This same authority come to the High Court straightaway without approaching the government.
But the same authority has reduced it. That is why difficult, madam.
Authority, then very difficult.
The authority who was granted the.
You can do the petitioner is who is the petitioner?
That is
Netaji
College of Nursing.
College of Nursing.
How have you described yourself?
Secretary. Secretary of the institution.
Secretary.
I described Netaji Nursing.
The
represented through its
petitioner claims that the Odisha Nurses and Midwives Registration Council has granted NOC for no objection certificate, bracketed NOC for opening of MSc,
My lord, MSc Nursing.
MSc Nursing course for the academic year 2023-24 with intake capacity 60 based on the said no objection certificate. The Odisha University of Health Sciences Bhubaneswar had granted affiliation to the college for MSc nursing program with 60 seats. Stop. Subsequently, the Chief District Medical and Public Health Officer Ordha had granted permission for undergoing clinical, practical and community training of 60 number of MSc nursing students for the academic session 2023-20 for the said academic session. Stop. The petitioner has grievance that the Directorate of Medical Education and Training has come out with a list of private nursing institutions for the said academic session 2023-24, wherein the number of seats for this institution, which reflects that number of seats for the present institution is only 25 as against 60, which was granted while granting affiliation by the university. Stop. Next, it is, what is the date of this notice?
This was published in the website, my lord. 8/2/24. At 8/2/24. It published. It test 22 Raj. Right hand column Raj. Special round of seat. It photo is the right hand column.
8/2/2024. So you impart only post-graduation degree?
There we have BSc nursing also. There is no problem.
And how do you say that this relates to MS post-graduation, this list?
All these institutions relate to the post-graduation only, man.
How do you say?
Because 23-24 BSc nursing is an old course in our institution. This is MSc nursing is only from 23-24.
Mr. Please tell us.
Yes, my lord.
The High Court.
Yes, I am sorry, my lord, but this is the for session 23-24 and it relates to the same institution. That is my instruction, man. Same batch of students. 23-24, that is why it relates to the MSc.
No, it is something else. PBBSc, MSc, PV, so and so, third round part. Everything is there. Oh, next. It is not clear from the pleadings on record and annexure 6, which is the 24 in there. 23. List of private MSc and institutions. Next. In our considered opinion, if according to the petitioner, the list available on the website of the directorate does not reflect the correct number of seats, the intake capacity of the petitioner nursing college, comma, the petitioner ought to have approached the authorities seeking amendment in the list. First off, the petitioner has straight away come to this court seeking a direction challenging the said list in the present rate application. First off, next, in such view of the matter, we dispose of this writ application with an observation that the petitioner shall be at liberty to approach appropriate authority under the Directorate of Health Services Says bracketed OP number
3, my lord.
Based on the documents which the petitioner had relied upon in the present case. Stop. In case any adverse decision is taken against the petitioner, it goes without saying that the petitioner shall be at liberty to assail the same before appropriate forum in accordance with law. The court expects, since the matter relates to an academic session, the court expects the court expects that the decision on the petitioner's representation, if filed within 2 weeks from today, shall be taken expeditiously, preferably within 4 weeks from making of such representation.
My lord, I am for Director of Medical Education and Training, OP number 3.
Why has this happened?
Copy has not been given to me. I have not seen the brief.
I have given it to the state master. I'll give it up.
Let a copy of the writ application has been served upon
Me, R.C. Mohanty,
Mr. R.C. Mohanty,
Director of Medical
counsel
Education.
who
Director of Medical Education and Training, Odisha, P3. OP number 3.
has appeared on behalf of Directorate Service.
Item 14.
May please, lordships. In this matter, your lordships, I have challenged Annexure 7 at page 35, your lordship. That is the demand for unauthorized.
Which item is this?
14.
Yes, madam.
Annexure 7, page 35 is under challenge, your lordship, where a demand for unauthorized extraction of morum has been imposed upon the petitioner. While for the self-same quantity, let's say the petitioner has already deposited the penalty amount at Annexure 6 series, let's say. Because
This order has been passed under which provision?
OMC rules, let's say. Odisha minor middle concession rules, let's say.
Which provision of that?
There is penalty provision, rule 51, let's say.
So there must be some provision for appeal.
Already have deposited that amount that was not taken care of, let's say. Only that is my use.
That you could have preferred. That you could have, this plea you could have taken.
Yeah, let's say
before the
during
afterthought.
personal hearing, let's say I bring this to the Tahsildar, let's say that I have already proceedings has been initiated by other Tahsildars for the self-same quantity, and the proceeding was continuing at that period. And the Tahsildars already penalized me and have deposited that amount, and the payment receipt challenge I have
No,
annexed.
this order was passed exercising power under section 51 of the Odisha Minor Mineral Concession. Question has been posed to you whether there is any appellate forum.
Yes,
taken.
46 of it like to something. You also can come to rule 46. Where you come to.
So you can defer an appeal.
Now this, because of this order, my employer has blocked my payment of bills, LRC, because that has been forwarded to my employer NHI. And now today NHI advocate is not present here. Opposite party number 1.
What? That is not material for.
Because I have already deposited the amount, that is my.
So that plea you can take before the appellate authority.
Yes, Lordship. And for the, Lordship, recently 2023 amendment has come, Lordship, because the Tahsildar has no jurisdiction to impose penalty upon me, Lordship.
What amendment has come? What is the amendment?
For imposition of penalty, now Tahsildar is also doesn't have jurisdiction, Lordship.
Where is that?
2023 amendment, recently it has come.
Please show us something. Where is that provision?
That provision is 51, Schedule 4 competent authority is the.
51 says that it can be imposed. You say that Tahsildar has no such power. So where is that thing?
Recently it has come and I have not annexed that part.
That can we not take that ground before the
Yes,
appellate?
I can take that ground.
Sure.
Yes, Lordship.
Counsel appearing on behalf of the in the present writ petition, the petitioner has assailed communication dated 4/1/2024 issued to the petitioner by Tahsildar Dharmasala, whereby demand notice has been issued for payment of a sum of rupees 45,40,000 for unauthorized extraction of morum, in exercise of power under rule 51 of the Odisha Minor Minerals Concession Rules 2016. Stop. Next, learned counsel appearing on behalf of the petitioner has argued that on the self-same allegation of illegal extraction of morum, other proceedings have been initiated which are pending.
No, that has been disposed of and I have already discharged my liability. And it was 6 inch.
Were initiated and pursuant to the penalty orders passed, pursuant to an order imposing penalty passed, the petitioner has already deposited
page 32 and page 34.
Requisite amount. Stop. See, however, agrees that the petitioner has alternative remedy of appeal against the said order dated 4/1/2024. Stop. In such view of the matter, this application is disposed of with a liberty to the petitioner to prefer an appeal under Rule 46 of the rules. Stop. It is made clear that if the petitioner prefers appeal within 15 days from today, the appellate authority shall not reject the petitioner's appeal on the ground of delay and shall decide the same on merits.
Your Lordship, on pre-deposit, Your Lordship, subsection, sub-rule 2 says that no appeal shall be admitted unless the amount demanded shall be deposited before the appellate authority. Already I have deposited that amount.
You
Again,
can take
before-
the plea.
Your Lordship, that
You
will-
can say
Your Lordship may observe.
the petitioner shall be at liberty to take a plea that the petitioner has already deposited the amount which is the subject matter of demand to waive the requirement of pre-deposit for maintaining the appeal. So we make it clear that we have not gone into the merits of such contention as to whether the amount has already been deposited or not by the petitioner.
So,
This application stands disposed of. This
That's
said
it.
application.
Already the payment receipts at annexes.
He said that it is for different tahsil.
The amount, yes, the amount of morum is same. The contractor is
That
same.
needs to be
and the work
adjudicated
is
by the
same.
authority. He has
That
to
will be taken into account, that my payment
That
receipts,
you may take that plea before the appellate authority.
this payment, Your Lordship, kindly clarify that I will take this payment receipt before the appellate authority.
You may take this plea. It will be up to the appellate authority to accept that or not to accept that. Because if that relates to some other transaction, then it's a different matter.
Yes.
But if that relates to that
Same amount?
then the appellate authority will
Let
consider.
them, they will verify, yes, sir.
We
They
have
will
indicated.
verify, yes, sir.
We have indicated that.
They will verify and then oblige it.
Item 15.
Item 15, Lordships, I have a limited grievance. The present petitioner is seeking a direction to the collector to consider his representation for renewal of his contract period for the year 2024-25. The present petitioner was the successful bidder for the tender works for appointment of transporting agent for midday meal schemes for the year 2023-24. Now, when the contract of the petitioner is still surviving, the new tender notice has been invited by the tendering authority. Now, I have already participated in such tender proceeding, but my right to renewal persists on account of clause 23(1)(2) of my tender of my contract, wherein the collector can extend the period of contract beyond the period of the original contract. So I'm just seeking that
By issuing fresh tender notice, the competent authority has decided not to renew your that period.
Yes. However, my representation to renew must be considered in terms of the clause of my tender, my contract.
No, but fresh tender notice has already been issued. Then
And
there was
I
a
have
question of,
participated also, but
and you have
right to-
participated also.
my right to renewal still persists.
How? That right to renewal would have persisted had no fresh tender notice had been issued. But since fresh tender notice has been issued, where is the question of?
And he has also participated.
Means I have already participated. It is the petitioner's case in the present rate application that pursuant to a tender notice for appointment of transporting agent for transportation of MDM food grain in Balasore district. It was selected as the lowest bidder. Stop. An agreement was accordingly, an agreement was there.
Yes, it is.
An
under
agreement was
annexure,
accordingly entered into which
Annexure 3.
which contained a renewal clause.
Yes.
The said agreement is still subsisting.
Yes.
Stop. In the meanwhile, a fresh tender notice has been issued by the collector.
By the collector.
By the collector, which place?
Balasur.
Balasur. Collector Balasur. Stop. Admittedly, the petitioner is participating in the fresh tender process. Stop. Next, Land Council appearing on behalf of the petitioner has submitted that despite the fact that the petitioner has participated in the fresh tender process, its right to claim renewal of the earlier agreement should be reserved. Full stop. Next, we do not find any merit in such submission. The petitioner cannot claim a renewal as of right. Stop. The respondents, the opposite, as is evident from the pleadings on record, the opposite parties have decided to float a fresh tender, pursuant to which the petitioner has already participated. Stop. In such view of the matter, no, the submission advance, the relief sought for on behalf of the petitioner by the petitioner cannot be entertained. Stop. This application is accordingly dismissed. On the fresh year, fresh tender notice and
Annexure 1.
for the year 24-25.
Item 16.
Item 16, Lordship, I am seeking an accommodation. My learned senior will conduct this matter. He is out of station today.
16, when?
Anytime next week.
Next week, 1 week.
Item 17.
Item 17, may I please, Lordship. Lordship, this matter is identical to today's specialist item 1.
Same matter.
Same.
Your Lordship appearing for opposite party number 4.
Same kar lo, I'm done.
Item 18.
May it please, Milords. Milords, I'm a contractor, Milords. I was awarded a tender, Milords, for construction of a government women's college academic building. Thereafter, Milords, when the work was being done, Milords, there was a change in the GST regime, where the GST rate, applicable rate, Milords, became from 12% to 18%. And thereafter, Milords, a circular was passed, an office memorandum was passed by the Works Department, saying, Milords, which Milords, if your Lordships, may I draw your Lordship's kind attention to that circular, which is at page 81. It's an office memorandum, Milords.
Yes.
Your Lordship has page 81?
Yes.
Milords, what it essentially does, there are 3 ingredients to a transaction, Milords. Number 1, Milords, is supply of services. Number 2 is the raising of invoices. And number 3 is the payment to be made. Milords, if 2 out of these 3 incidents are happening after the cutoff date, that is 18/7/22. If 2 out of these 3 incidents are happening after 18/7/22, then the new rate will be applicable. If not, then the old rate will be applicable. So, Milords, the question here is, Milords, where my invoices that are there, Milords, although, Milords, the supply of services was prior to the cutoff date, but the invoices were raised after the cutoff date and the payment was also made after the cutoff date. Milords, may I kindly take your Lordship's for a moment, Millards, to the page 85, Millards, the invoices. This is the second round of litigation before your lordship, Millards.
What happened in the first round?
First round, Millards, since I had made a representation to the authority, your lordships directed the authority to consider the representations in accordance with law, and the law is this office memorandum. But what the authority does, cites this circular, Millards, also relies on a clarification issued by the GST department, which also says the same thing as the circular, but says no, you will get 12%. Millards, it is completely arbitrary. There is no possible way how these two ingredients out of three are not attracted in my case. That is my simple case before your lordship, Millards. If your lordship will kindly see the invoice, Millards, it will make things clear, Millards. Page 85. Two invoices, Millards, are under question, Millards.
Yes.
Your lordships, at the top, will see the date, Millards, 11 September 22.
Page
85.
Yes.
Millards sees page 85.
Yes.
At the top, 11 September 22. So this is admittedly after the cutoff date, that is 18/7/22. And Millards, the next page is the invoice dated 24th March 2023. So these are the two invoices, and as your lordships know, the payments are also made pursuant to these invoices. So two incidents arise after 18/7/22. In this light, Millards, your lordship will kindly see my representation, Millards, at page 94.
Yes.
This is the representation dated 27/5/23, Millards. I want to bring to your time notice that I have submitted the measurement on such and such on 30th April 23 as final bill for aforesaid bills, but invoice had not been raised because of deviation approval pending. And until the deviation has not been approved, till that the bills are also not finalized. Hence, my final bills of deviation approved on 29/12/22. After that, I have been raised invoice in the new rate of GST, which is applicable as per letter number such and such dated 6/10/23. Now the matter is that the bill which payment released by your good office in 12% in place of 18%. The invoice generated in 18%, which authenticity may verify in GST portal against your bills payment. Hence, the bill finalized on 29/12/22 and thereafter payment released part by part after GST rate changes from 17/7/20. Therefore, I request you to kindly release 6%, of the differential 6%, which show liability in GST portal. So I will be grateful to you. Let's make pardon the language. It is written in a very thereafter, if your lordship will kindly come to the rejection, or may I take your lordships to the order passed by your lordships at page 16. 16, 16. My lord's order.
One six is nothing but a direction to consider your representation.
Yes. I was just showing that order. But it says in accordance, it should be in accordance with law. Since there was a representation.
No, even if it was not there, everyone is to act in accordance with law.
Yes, your lordship, absolutely. I completely bow down to that. We'll see the rejection, at page 15.
Page
15, 15.
Yes.
I'm sorry,
1, 2.
1, 2. Well, 1, 2, it starts.
Yes, this is your representation.
This is the impugned rejection.
12.
Page 12 is the covering letter. The recording is overleaf. The next page. 13.
But why is this addressed to the Advocate General?
Well, because there was an earlier round of litigation, perhaps that's why it was addressed. It is, your lordships will see at the bottom, it has been forwarded to me. At page 12, it has been forwarded. May I please page 13, minutes?
Yes.
Well, sir, the second para, third para, if I make place, it is ascertained from the MB, that is the measurement book, that the measurement has been taken up before revision of GST on with effect from 18/7/22, as per the bills raised by the agency to the section officer concerned, but payment has been made during the month of 9/22, that is September 2022, March 2023, April 2023, May and June 2023. As per Government of Odisha Works Department Circular such and such, and clarification from the Additional Commissioner of CT and GST Territorial Range Sundargarh, with a letter number such and such, it is ascertained that it comes under serial number 2 of the table of circular, as the measurement has been taken up. We'll see, because the measurement has been made before the rate change of GST. Hence, rate of GST has been provided as per old rate, that is 12%, as per the circumstance, and clarification received from the authority. Because the measurement was prior, that's why, I have been given the old rate. But the circular says that 3 ingredients: 1 is supply of services, 2 is date of raising of invoices, 3 is payment made. So here, admittedly, raising of invoices and payment made is after the rate change. So the new rate will be applicable. That is my case for this.
But is that you are submitting that if 2 out of which
yes, that is at 80 yes, the circular is at 81, which I showed let's say 81. This is a chart. Column 1, 2, and 3 are the 3 ingredients: date of supply of goods or services, date of issue of invoice, date of receipt of payment. If the date of supply is before change of rate, but date of issue of invoice is after rate change, and date of receipt of payment is after rate change, then last column will see rate of tax applicable is new rate. This is also clarified in a simple term in the next page, para 2. It's paraphrased, if any 2 of the aforesaid 3 events, that is supply of goods or services or both, issue of invoice and receipt of payment, occur before the rate change, old rate of GST is applicable. However, if any of 2 of the 3 events occur after rate change, then new rate of GST will be applicable. So measurement is not a criteria for the purpose of depriving me of the changed rate.
No, measurement will come under which column?
Supply. It will come under supply.
1.
Yes, 1.
Yes.
I will file a counter affidavit.
Fine. Issue notice. Learned AGA accept notice and waives. Thus waives issuance of requirement of issuance of notice. Stop. Yeah, have you received copy?
My lord, I have.
4 weeks time is allowed for the estate to file counter affidavit. List this matter on 6 weeks. Time in the meanwhile may be utilized by learned counsel for the petitioner to file rejoinder if so advised.
Item 19.
Item 19, Millards, in absence of GST tribunal, the petitioner has approached this honorable court. This is similar to special list item number 1.
Item
20 also.
20 is the same.
And 21 is also Millards same.
Just a minute.
Oh.
2021. Item 22.
Please, your lordship.
Manoj.
No, the similar matter, my lord, yesterday item 24. my.
Let the matter be called.
Matter.
Which similar to which?
Item number 24, my yesterday, lordship.
Yesterday list item of 24, my lord.
Yesterday.
Same party, only the query is different.
24. Hey,
Yesterday.
That matter. Yes.
Problem loss. Item 23.
It's a contempt, my lord, non-compliance of the order dated 4th July 2023, your lordships. Annexure 1, page 10 is your lordship's order.
Yes, it has not been complied with.
Paragraph 5, there is a direction to programs for the reproduction. Then
6 weeks.
I hope it will happen in the otherwise I will see that.
It's not done, my lord. Today morning it is not complied with.
As requested on behalf of the opposite parties, list this matter on 6 weeks to report compliance of this court's order dated 4/7/2023, passed in WPC number 19993 of 2023.
Item 24.
But there is a, my lord, 24, my lord. Lords,
24 we have.
no, there is a typographical error in order, my lord, last order. Order number 4, it is 2020.
24.
It is to be 23, my lord. The order number. It's a case number, it is tagged only, my lord. Order number, 1st February 2024. The case number 2023. And
Oh, there's something else.
in top case number, it is 39578 of 2024. It should be 2023.
There is a apparent typographical error in the order dated 4th order. 4th or 1st? That is 39578 of 2024. Oh, what up? 20 in place of 24 in place of 23.
Only year is.
So the said order number 4 dated 1/2/2024 shall be treated to have been passed in the present
So in this case, Willards, prayer made in this application is Willards subject matter of one of the prayers in the connected petition, which your lordship have seen yesterday, Willards, for which case I have prayed for non-writ petition. I have prayed for withdrawn writ petition.
withdrawal.
Infractions, your lordship, this prayer is infractions.
Yes, with an observation matter connected to one of the prayer in the.
It is simply infractions because your lordship, this here the audit has been challenged. Pursuant to audit, show cause notice have been issued. Show cause notice is under challenge.
Apparently, receipt application has become infructuous. And
Writ petition number we mentioned, WPC.
No,
No, teacher.
yes, that is not required here.
In view of that, I will permit to withdraw.
And dismiss as having been infructuous. A memo submitted on behalf of the petitioner is taken on record in this.
Item 26.
Lordships,
Just keep it.
we would want to comply with that supplementary affidavit, and this of course would take some time, though a very short point is involves a service matter.
This is WPC number 42375.
I'm appearing in 8290. That's the first one. And
90.
and then there's a state writ petition also.
Right. Yes. Yes, madam.
Lordships, we'd like to supplement, and I think it will take some time. It's already 1 o'clock, so we'll put it for another day and we
My
can.
lord, in connected matter, my lord, that is WPC number 15877 of 2016, we have filed one IA for intervention, my lord. IA number 13534 of 2023. Here, my lord, what is our intervention was allowed in the previous case, and that case has already been dismissed for default, my lord. For which, my lord, we have filed the present IA for intervention in WPC, in this the connected matter that has been filed by the state.
So you filed an intervention application in a case which has been dismissed for default.
Yes, my lord.
Then
that was also previously connected with this case, since that has been dismissed.
So you should be happy that in the case in which you file your intervention application has been dismissed.
No, my lord, we will be affected, my lord. I have also mentioned in the IA page 7 and 7, my lord, have a glance.
So in this case, what you have to say?
In that case, we are not the party. In
That-
the connected case, we have filed.
You want to file a supplementary affidavit?
Yes, we'll file a supplementary. In those cases he's talking about,
That is
the writ petitioner did not pursue even after repeated calls.
Then-
So I think that is finished.
My lord, we will be affected by that order.
Which order?
My lord, have a glance.
Dismissal in the other writ petition, the intervener is adversely affected.
If the writ petition filed by the state will be allowed, then, my lord, we will be affected.
My lord, the order.
State, that has been filed by the state.
This WPC 15877 of 2016, it has already been disposed of.
No, man, that is still pending.
It is pending.
7756 has been disposed of where our intervention was allowed.
What can be done? You don't have any locus.
He has filed another case. He has filed another IA in the present pending writ petition. That is what he
All
said.
right, that we will consider.
Man.
The same order, the same order of the tribunal is under challenge before this honorable
We will
court
see,
in
we will-
instance of
we will-
state and also.
Learned counsel for the petitioner.
This files to be disposed of to be intended.
We'll take up on the next. How much time?
Unless it's 2 weeks.
2 weeks. 2 weeks time is allowed for the petitioner to file an additional affidavit.
This is supplementary affidavit, he said.
Supplementary affidavit. Stop. As requested on behalf of the petitioner. Full stop. Comma, they will, as requested on behalf of the petitioner. Only this case on 2 weeks.
This WPC.
Along with WPC number 15877 of 2016. 2016? Yes. Yes.
Item 27.
My senior Mr.
My lord, I'm on virtual. They were supposed to be filing their response, stating their response, my lord. Very recently, my lord, they've again given to 20 other institutions like this, my lord. May I be permitted to file an affidavit to that effect? Very recently, my lord.
All right. So you want to file a supplementary, huh? Your learned counsel for learned senior counsel appearing on behalf of the petitioner seeks adjournment as according to him, a supplementary affidavit. An additional affidavit is required to be filed. Stop. List this case. When do you want?
1 week, my lord.
List this matter on 1 week for the said purpose. Yes.
28.
May I please, your lordship? No, the petitioner being the member secretary of a NGO participated in the tender process and as he is become the highest bidder, the project under NHM, National Health Mission.
So what was the work about?
Conducting the Dhansuli PHC, primary health center in the district of Kalahandi. He has been allotted and he continued to monitor that project and conduct the project from 2008 to 2019. And thereafter, in 2019, the project was again, your lordship may kindly come to page 17, Annexure 1. Dated 31/8/2019.
So you have been blacklisted.
You
have been blacklisted.
Yes, my lord.
None
without any reason, without any inquiry, nothing.
Where is that order?
My lord?
Where is that order of blacklisting?
No order has been passed, my lord. Your lordship may kindly come to page 21. Rejected adverse report against the organization. No order was passed, my lord.
Yes.
Without hearing also, my lord.
But it was passed in sometimes in the year 2019.
My lord. The writ petition was presented before this report in the year 2020, my lord.
Yes. So what purpose will it serve now? After 4 years.
As the NGO was blacklisted,
there is no blacklisting. There is no order of blacklisting. There was some adverse report because of which a particular work was not allotted to you. That's all.
No, Lord, that was blacklisted. Your lordship may kindly come to page 33. Page 33, lordship.
Yeah.
17. Serial number 17.
Serial number?
17, Lord. Page 33, serial number 17. Lord. If based on any adverse report, again, the organization from district, NHM, any government departments, the partnership of the organization has been discontinued or due to poor performance in implementation of public-private partnership projects under National Health Mission is identified by the external evaluating agency, then the organization shall not be eligible to apply for the same district for the same project. In case the service of the organization has been discontinued on the basis of conduct of financial irregularities, it will not be allowed to apply in any of the district under any scheme. So since 2019, the organization is not able to apply for conducting.
No, did you apply?
At that point of time, I have applied. Not.
No.
That is not Annexure 1, Lord. Serial number 4, Your Lordship. Page 17. Insert of Dhansuli, not qualified.
That we have seen. That we have seen.
So what is that adverse report against you?
No, it's not.
Because that again which you
for
For that, no inquiry has been conducted, no notice has been said.
That is of two kinds. One is that you come to that, just you are showing that one, if it is financial one, then you cannot participate anywhere, financial irregularities. But if it is for some other poor performance for that very project, so please see that number 17 you are placing.
Yes, my lord.
So what kind of adverse report was submitted against you?
And in their counter lordship, they have inquired, they have stated in their counter. They are stated in the counter, there is an allegation against the present petitioners. Your lordship may kindly come to.
Whether it relates to financial irregularities or poor performance.
There is no financial irregularity. Rather, the allegation made by some people of the locality that there is no medicine, the doctor is not available. These are the small allegations against the petitioner's NGO.
As these allegations are small, how can the medicine is not available in a PSC? And it's
Medicine is available, but at that sometimes there is the shortage of medicine in for some diseases.
Yes, what is your stand? He shall not be given any work.
No, my lord.
The NGO will not.
The entire fact has not been placed. My lord, may can see by virtue of lapse of time, the writ petition has become infructuous. My lord, may kind turn to page 25.
Yes.
That is the request for proposal for formation of a partnership firm so that the selected bidder will operate the primary health center for a limited duration. Well, this was issued on 7/2/2019. Next page is the public not-for-profit partnerships. That is the partnership name. Now the duration period, my lord, we can turn to page 40.
40.
Yes, 40. To manage such facilities by demonstrating models for comprehensive primary health center. 4.6. The partnership will be initially for a period of 1 year. Subject to the agency scoring 70% or more in annual assessment after completion of 1 year of project, renewal of the partnership will be considered on the basis of the evaluation conducted by the concerned district NGO committee. Well, this period of 1 year, well, had it been selected, that period would have been expired in the meantime. And the next term is, next page, my lord, we can turn to page 50, clause 7.5.
The only question which is involved in this case is as to whether he is being debarred for the future.
No.
Have you taken his stand?
No, you also can see that is a part of the tender call notice. That tender call notice period has expired. That is why I placed.
In that tender notice, he was disqualified because of adverse report against him.
But that was the condition stipulated in the tender call notice itself. There is no blacklisting order.
No blacklisting order, but there was some adverse report against him.
Yes, that was taken into consideration and the bid was rejected.
All right. But whether that adverse report shall be taken into consideration in all the tenders
in future.
No, that is not mentioned in the counter because we have stated in the counter.
You will have to take a stand.
Because no blacklisting order has been passed, that we have stated.
There is no question of blacklisting. You are rejecting his papers on the ground that there was some adverse report.
Yes.
So you may take that stand in each and every case.
Yes, because the poor performance.
Therefore, poor performance should have been made known. That this is the reason why your performance has been found to be poor. He could have explained. Or you take a stand.
No,
that will be not that will not be a ground for future rejection.
No, that we have not stated so far as
you will have to take a stand.
File supplementary.
And counsel representing the state is permitted to file a supplementary affidavit as to whether because of any adverse report against the petitioner, he shall be disqualified to participate in future tender processes for
Dhanasuli Public Health, Primary Health Center, madam.
for
Dhanasuli Primary Health Center, madam.
For any,
For any, what is that, where is that, you pointed out that, that adverse report, that
33, madam.
30?
Page 33.
17, madam.
Just.
See, based on any adverse report against the organization.
33, okay, page 33, last one, 17.
Page 26 is the work.
Just.
page 26.
That's 33.
Public not for profit partnerships for operation and management.
For operation and management of primary health centers, bracketed PSC under NHM, Odisha. Stop. Okay.
Because of any adverse report against the petitioner, he shall be disqualified to participate.
For this said purpose, let this matter on 4 weeks. Yes.
Only adverse report of loan performance only with for the same project. But if it is for the adverse report for any financial irregularities,
Adverse report.
Against the petitioner.
Adverse report relating to poor performance / financial irregularities. Yes.
Your Lordship, call it, did
4 weeks.
But, can I make a mention? Item number 9. Item number 9 is the private complaint arising out of a private complaint, and the complainant is also there. And they under section 430 of the Companies Act. So otherwise also not one with next week.
So it has become infractuous then?
Should have been. That's what I submitted in the previous court where it was heard. Because this case is, it should be, if order should be passed and it should be.
No, he is dead, then
the order of conviction has to go, because I have come against the order of confirming convictions. Initiated at the stage of a private complaint. And the complainant is dead.
So what will happen after the death of the complainant?
The prosecution should be passed.
We will see.
That we will see. That exactly. That is what I said, that as such today's reference also, if your lordship might give me time, 1 week time next week, I'll be happy.
For what?
Adjournment for hearing.
We will see, let the matter be called.
I make pardon, my lord. Item number 6.
When should I raise? See, we will be assembled. Judges कहाँ assemble हैं?
Number 6 of the supplementary list, who tried to permit to withdraw. I have already filed memo to that effect.
Item 6.
6 of supplementary list, arbitration matter, and my learned brother appearing for OPs on VC.
Item number 6.
Permitted to arbitration.
Arbitration.
Much obliged.
Withdraw first.
Pardon to mention, item number 30. Item number 30 kindly be taken after 1 week.
Item number
30.
Which list? Criminal division? Criminal division?
Yes.
Let the matter be called first. Make a mention when the matter is called.
Item 15, it has become impulses.
Item number 1. CR REV 185 of 1998.
Yes. There is no representation on behalf of the petitioner. Petitioners list this matter on next Friday.
Item number 2.
There is no representation on behalf of the petitioner by previous order dated by the last order dated 22/4/2022. Mr. Pratima Das was appointed as Ms. Pratima Das was earlier appointed as an amicus curiae. First off, list this case on next Friday. First off, let Ms. Pratima Das be informed about the adjournment of the case to the next date. Next.
Item 3.
No one appears on behalf of the petitioner. This application is accordingly dismissed for default. The interim order stands vacated.
Your Lordships, I'm in VC, Your Lordships. I'm appearing for the opposite side CBI, Your Lordships, Central Bureau of Investigation.
All right. Yes, next.
Item 3.
3. Both cases. Just a minute. Yes, both the cases. Both the cases.
Nice. Item 4.
Item 4, I may be pardoned, my lord. Lordship may give me 10 days time. The file has been misplaced. My lord, only 10 days time I seek, my lord. In that time, my lord, as a last chance, my lord, I pray 10 days time.
As requested on behalf of the petitioner, list this matter on 2 weeks. First off, it is made clear that the court shall not grant any adjournment, any further adjournment, as the matter is pending before this court for last 24 years.
Division 867 of 2004. On behalf of my senior, Mr. J.R. Das, Your Lordship, actually, we do not have any present status of the petitioner or anything. If Your Lordship may permit for one or 2 weeks.
As requested on behalf of the petitioners, who is appearing in the first case?
Sir, I am for the past case.
103.
103, man.
You are for?
For petitioners, my lord. Two
Petitioners.
petitioners.
So
Yeah.
whether he is alive or not.
Well, that I don't know.
Huh?
We have no instruction that I got.
On behalf of the fourth case, madam, I requested on behalf of the petitioners list this matter on 2 weeks for them to seek fresh instructions.
Item number 6.
On behalf of Mr. N.C. Mahanti, my Lord Senior for opposite party, I submit that opposite party number 1 has died in the meantime. And we have no instruction regarding other opposite parties, my Lord.
Yes, I am for the petitioner in this matter, my lords. I will also seek some accommodation to seek instruction, my lords. Though this, I am ready with this matter because it was
On behalf of the petitioner list this matter on 2 weeks so as to enable him to seek instructions.
Item 7. Item number 7.
There is no representation.
I am the respondent. The file.
There is no representation on behalf of the petitioner. This petition is accordingly dismissed for default.
So far as government appeal number 12 of 2002 is concerned,
That is also, yes.
there must be a challenge the order of acquittal. It's a case under section 366, review section 376 and 34 IPC laws. The lawsuit placed to grant and leave for appeal on behalf of the state, and my friend appears for the respondent, those who have been not acquitted.
There must be some merit for this court to grant you leave. What is the merit? Leave has already been granted. Then are you on merits?
That's why I'm not saying no. So I was about to say, my friend says he appears for the respondent. He said that he doesn't have the brief, so he wants time. I don't know.
One is time.
एक को लिखना डिस्मिस फॉर डिफॉल्ट, जीए को लिखोगे as requested on behalf of the parties, list this matter on 2 weeks. These matters are unnecessarily pending.
No, but this I can I'm ready. There was this state was only one point, whether all the sole testimony of the prosecutor is the conviction can be heard, and whether the crime is justified in acting the law so active person on circumstantial evidence. That will take.
Yes. Item 8.
No one appears on behalf of the petitioner. This application. is accordingly dismissed for default.
Item 9.
This matter, you also can see the order dated 26/10/2022. I submitted that the OP, complainant OP debt. And according to some order has been passed, it's a complaint on submission of final report in private capacity. A complaint was filed under section 630 of the Companies Act without having any jurisdiction and without having any authority under the law. And they mechanically they proceeded and found the petitioner guilty. The whole of the judgment, both are wholly perverse. It is not there. It may take also some time.
Why?
No, if a lordship wants to hear, because the opposite party is not there. He is there. And 630, your lordship knows it's instituted by the company, but it's a complaint is not instituted by the company, as defined under section 630 of the Act. The thoroughly perverse prosecution from the beginning to the end. Both way the impugned orders are liable to be quashed in absence of the complainant and opposite party, as well as the impugned orders are perverse.
Two orders have been passed in this case.
Madam?
32 orders have so far been passed in this case.
In many courts, I have argued, but halfway there. That is why today also I'm not feeling comfortable because I must have argued around 4 to 5 courts. In last court, I argued completely. All views were taken to pass the impugned order, but I don't know how it has been again left open to your lordship. It was heard on 15/12.
From the previous orders, it transpires that the opposite party number 1.
All the sole opposite party, complainant opposite party.
Complainant opposite party is no more. So, and counsel for the petitioner is seeking adjournment. So, place this matter on 1 week.
Item number 10.
Your lordship, here in absence of the opposite party. On that day, your lordship is here in absence of
opposite party cannot come. It is very difficult to notice upon him.
That is what your lordship adjourned or the.
We have adjourned for a week. We will hear you next week.
Item number 10.
No one appears. Is this matter on next week?
Item 11.
Item 11, my lord, order dated 7/12/22 may kindly be seen. There is a report by officer in charge Tiring Police Station that the present appellant is dead for last 5 years. That is
Then
And submitted. Not want me to seek instructions, I'll seek it in a week.
no, if he is dead, then why should this revision petition
appeal abates?
there is a order, my lord, dated 7/12/22, my lord. In response, 7/12/22, my lord. In response to that order, OIC Tiring PS made an inquiry and has reported that
this is criminal division 131.
131, my lord.
Lots of 99.
Order नहीं है ना. 26/10/2022, there is an order of this date.
It is Raghunath Patra, my lord. 131 of 1999.
Order has.
The noting shows not received.
No, where is the order to the effect that he is no more?
That is the report I am reading, my lord.
The report.
Yes, yes.
No, report is not there. You are submitting.
Yes, yes.
Look, it was called for, and the noting also shows that the report is not received, which is why it is not on Milot's file.
Now he is reporting.
He has a copy.
You are, if he
Government Advocate Jyoti Prakash Patnaik.
learned government advocate, Mr.
JP Patnaik.
JP Patnaik has informed this court based on a communication made by the officer in charge, Tiring PS, addressed to the office of the Advocate General, that the petitioner of this case died long back. Stop. This application thus abates and stands disposed of. Yes.
Item 12, wait for a moment.
I don't know on behalf of the Guru Kora, matter can adjourn next week. Matter can adjourn next week.
As requested on behalf of the petitioner, list this matter on 1 week.
Item 30.
Your Lordship, item 12, I am appearing on behalf of CBI. Your Lordship, I request the counsel for the petitioner to provide me a fresh copy of the revision. Your Lordship, it's an old matter.
Can take that from him. Give him a copy. Yes, I don't.
Item 13.
Well, Lordship, since item 13 is an old matter, we need some instructions from the petitioner also, Your Lordship.
As requested on behalf of the petitioner, so as to enable her to see instructions as regards present whereabouts of the petitioner. Is this matter on 1 week?
Item 14.
Much obliged.
So many petitions. So many petitions are there. Huh?
Item 14. 144.
No, 113 is what sort of petition? 12. All right. Next, yes.
14. 14.
One appears on behalf of the petitioner. This matter on the day. Next week.
Item number 16.
Yeah, that's the behalf of Mr. Dibyajyoti Sahu. Item 16 and 17. To inquiry sought adjournment, Your Lordship.
Adjournment. How much time?
1 week time, Your Lordship. He's out of station.
Requested on behalf of the petitioner. This case on 1 week. दोनों का लगन 16 and 17.
Item 18.
Okay.
No one appears on behalf of the petitioner. So application is dismissed for default.
Item number 19. Item 19.
There is no representation on behalf of the petitioner. His whereabouts have also not been ascertained. Of this revision application is accordingly dismissed as not pressed. The interim orders stand vacated.
Item 20.
There is no representation on behalf of the. There has been no representation on behalf of the petitioner on consecutive dates. Stop today also, there is no representation on behalf of the petitioner. This application is accordingly dismissed for default.
Item 21.
Interim order stands vacated. There is no representation on behalf of the petitioner. Despite order of this court dated 26/10/2022, the whereabouts of the petitioner have not been made known to the court. Stop this application. Is accordingly dismissed for default.
Item 22.
I'm appearing for the petitioner, my lord, that I want some instruction. This matter will carry court 10 days after, my lord.
When counsel for the petitioner states that since this matter is 24 years old and she does not have fresh instructions as regards the petitioner's whereabouts, whereabout, comma, this matter may be adjourned for seeking instructions. Stop as requested, list this matter on 1 week.
10 days after, my lord. 10 days after. We want some instruction from him, like the correspondence with him. 10 days after.
2 weeks.
My lord.
Item 23.
No one appears on behalf of the petitioner. It appears from the order sheet that after obtaining an order for the petitioner's release on bail during the pendency of urgent revision application, there has been no representation on behalf of the petitioner. So accordingly, the bail bond. Accordingly, the bail bond and sureties. Accordingly, the bail bond furnished by the petitioner for his release on bail shall be treated to have been cancelled. Yes, item 24.
Before may I please, my lord, here out of 7 petitioners, 2 are there in the meantime, my lord. The petitioner number 3 and 4, my lord. Now, petitioner here challenges the conviction passed by the learned JMFC and which is subsequently upheld by the additional session judge Baripada under section, my lord, 148, 341, 506, 325, and 149, my lord. The maximum sentence imprisoned to the petitioners, my lord, 1 year. And there, my lord, 8 accused persons. Out of 8, my lord, the 8th person who is a 90 years old.
Provision of offenders Act. Can we apply that provision?
My lord.
Provision of offenders Act.
My lord, section 4.
We can dispose of provision of offenders Act. All right, well, I'll dispose it off.
My lord.
I'll be to rise today.
My lord.
Huh? Just a minute. And counsel for the petitioners has stated at the outset that the petitioners number 2 and 4.
No, 3 and 4.
3 and 4.
My lord.
Died during the pendency of the revision application. To stop. This revision application, to the extent the same relates to petition number 2 and 4, abates and stands disposed of. Stop. In the present application, under section 397, read with section 401 of the CRPC. The petitioners have assailed an order dated what is the order of the appellate authority? Appellate
My lord, date of judgment, 20th May 2000, my lord.
dated 25/2000.
My lord, 2000.
2000 passed by learned
Additional Session Judge Baripada.
Additional Sessions Judge Baripada
My lord.
in criminal appeal number 4/94 of 2000/1991, upholding the judgment of the trial court of conviction dated. What is the date of conviction?
My lord, 6 July 1991, my lord.
6 July 1991.
My lord.
In TC number 284/90 for the offences punishable under sections 141, 341, 506, 325, read with 149 of the IPC. Stop. By the impugned judgment of the trial court, the petitioners stood sentenced were sentenced to imprisonment for 1 year for the offence punishable under section 148 of the IPC, 1 month for the offence punishable under section 341 IPC, 1 year for the offence punishable under section 325 IPC, and 6 months for the offence punishable under section 506 of the IPC. So next, this criminal division has remained pending for 24 years. Stop. What is the maximum IPC penalty? What is the maximum punishment for these offences?
My lord,
148, 341.
325, it is maximum, my lord, 7 years.
No, that has been
For 325, it is maximum 7 years. my lord.
7 years. All right. In the peculiar facts and circumstances of the case, and keeping in mind the fact that this application has remained pending for 24 years, in our opinion, the interest of justice shall be subserved if the petitioners are directed to be released on provision of good conduct in exercise of power under section 4 of the Probation of Offenders Act. Full stop. I accordingly dispose of the present revision application modifying the disposal of the revision application and instead of upholding the sentence of imprisonment, comma, direct the petitioners to be released on probation of good conduct on their entering into a bond without any sureties to appear and receive sentence when called upon for a period of 1 year. Deeply pledged. This application stands disposed of.
The second list, my lords, item number 9. I filed a memo for withdrawal, my lords. Let it be, my lords.
Item number 9.
Your lordship's leave. May I mention item 4 in the arbitration list?
I will have to.
Next week,
I'll have to rise. It will come next week.
Very good.